My
Lordship.
Lord, I can confirm that you have complied with the order of the cost of course
And you have purged yourself of contempt.
as the court pleases, my Lord.
Pardon?
Upon his
Yes, his hands are clean.
yes,
So he can now eat in the court of equity.
as God pleases. Yes, we are grateful to your Lordship.
So you confirm receipt of the cost?
Yes, we confirm it. Grateful to your Lordship.
So can we proceed? Yes. We have how many witnesses? Just one witness. What documents are you relying on?
One document. Only one document. And gladly, that, my Lord, I'll mute.
Please, if you are not speaking, turn off your speaker. Mute yourself. Gladly, it is the same email that I objected to on grounds that it wasn't legible. Okay. So I thought to bring the legible on the also for it. The witness has that. I have a printed copy. Does the witness have that email? Yes, it was okay. So you are ready. So Memo, you are ready? Yes. Registrar. So notify your witness that the witness will be sworn by the court registrar. She's to look at the registrar and respond accordingly. She may have to affirm, so she will need to raise up her right hand. Say after the registrar. I want to go there. You want to go there?
Yes. Oh, okay, my Lord. The witness is already in position. I think she got. So you can.
Please kindly raise your right hand. And repeat after me. I. Your names. Mention your names.
Susan Fisher.
Affirm that.
Affirm that.
The evidence I shall give.
The evidence I shall give.
In this case.
In this case.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
You, Susan, you are hereby cautioned that if you tell a lie in your testimony in this proceeding or willfully mislead this court, you are liable to be prosecuted and informed guilty. You'll be seriously dealt with according to law. Do you understand this?
I do.
Thank you. My Lord, the witness affirmed. I caution pursuant to section 206 of the Evidence Act. Thank you. The address on the witness deposition is still valid? Yes, ma'am. And their designation is still valid?
Yes, my Lord.
Yes, we're ready.
Yes, ma'am.
So I have the name, have the address, I have the designation. So let's proceed to
Okay,
another.
I'm grateful to the court. So we'll dispense with introductory matters. Witness, do you recall signing or swearing to a witness statement of oath in this matter sometime back?
I do.
Okay. If you see a copy of the statement you signed, which was notarized in England, will you be able to identify that exact copy that we intend to present to the court
I will.
this morning?
I will.
My Lord, I apply to show the witness. Okay. So I would, let me show you a better screen. You can open it on the other side. Okay. Can you see this?
Not quite, sir. You just need to turn it towards the camera.
Okay. Is this better?
Thank you. I can see that.
Okay. This is, I'm your lawyer, and then I'm actually showing the right document, but just for records, please confirm some of these things. You can see your name here, and
Can you
I
go to the
want to believe you have a
signature
copy of
page?
it. Okay. I'm going to the signature page now that has all the. So can you also see the signature page ending at paragraph 40?
I can, yes.
And you can see your signature as well.
Yes, yes, sir, I can.
So, so you confirm this is your witness statement on oath.
Yes.
My Lord, we know a copy is already before the court attached to the statement of defense, my Lord. We humbly refer to that. So what do you intend to do with this statement before the court?
What do I intend to do with?
Yes, with the statement.
Yes, it's to explain the side of Cellulant and how Cellulant saw the matter at hand.
So I take it that you adopt your witness statement of oath as your evidence.
Yes, exactly.
My Lord, the witness identifies and adopts statements on oath, the post-truth on the 4th day of November 2024. Yes. So in this very statement, I think specifically paragraph 13, you refer to an email you sent to the claimant. If you see a copy of that email, will you be able to identify it?
I'm sure I would, sir.
Okay. My Lord, I'll display the email. Can you see it clearly? So
Yeah,
I'll just,
yes.
okay. So is this a copy of that very email? Please speak for the courts to.
Yes.
Thank you, Mary. Thank you. My Lord, we seek to tender the email. My Lord, in compliance with the rules of this honorable courts, we have also attached, my Lord, I'm sorry, in compliance with the provisions of the Evidence Act, we've attached a certificate of compliance that accompanies the very email. My Lord, we seek to tender in evidence. No, not at all. November 13th, 2023. Right. My Lord, just for reference, it's also the same Exhibit 11 the claimant tendered. Mm, mm.
The email dated 11th November 2023,
13th November, my Lord.
13th November, sorry, 13th November 2023, with the attached certificate of compliance, submitted in evidence and marked as the due one.
So, Mrs. Foche, please, one last question, if you can hear me. So, what do you want this law to do for cellulant?
I would like the court to hear the case for Cellulant and adjudicate what the court deems is objective and right. We tried our best to follow the process and to ensure that parties are heard in this case and to separate in a way that is provided for within our disciplinary processes as well as the Nigerian legal system.
My Lord, I would take it that she means the court should look at the case objectively and give judgment in Cellulant's favor. As the court pleases. She said, based objectively, as they have tried to comply and as the court pleases. My Lord, that will be all for examination in chief. I will hand over my witness to the claimant's counsel to treat with utmost caution and care. As the court pleases. As the court pleases. Hello, we've done this very quick, but because of the law student, I will mention it. I will do that. So, witness, I'm handing you over for cross-examination, I've mentioned. So, you would take time to hear the question first,
Yes.
then wait for the judge to prompt you to answer, because the judge is also writing in longhand.
Okay.
So once the judge prompts you to answer the question, that is when you would answer the question. And your answer, as much as you can, be straightforward to the question, address the question you are asked. So that's to the best of your knowledge. And slowly, as the court will also be taking note.
Thank you. Understood.
Welcome, ma.
I'm sorry, sir, you're on mute.
So good to have you here, witness. My Lord, please, may we have Exhibit D1.
Sorry, let me also, please, when you refer to the exhibit, it will be appropriate to perhaps just go to the dates and the subjects. So she will follow. We are the ones who know them as D1D.
Witness, Exhibit D1,
And
document you just tendered now, the document you tendered, the email of November 2023.
that email.
So in that email, you were responding to the claimant's own email of 7th November 2023. Can you hear me?
I can hear you, sir. I'm just not sure if you're asking me to confirm if I've
I
seen.
want you to confirm that that email, the one you just tendered now, of 13th November 2023, that's the only document you tendered. Can you see it?
I can see it, yes, sir.
But they call the document you tendered now in court.
Yes.
It was an email written to you, to the claimant. Is that correct?
That's correct.
In that email, among other things, you stated in the second paragraph, Cellulant takes your allegation of discrimination and team attrition seriously and assures you that an investigation will be conducted. The company is committed to addressing and resolving the issues to ensure a safe, fair, and inclusive work environment for all employees. That was what you said in that email. Is that correct?
That's correct, sir.
My Lord, may we also have Exhibit 8? Don't finish with it. 8. So in Exhibit 8, it is the email the claimant wrote to you and the CEO, to which you responded by your email that we just dealt with now. the claimant made a lot of complaints there. In the last paragraph, the claimant said, "I am desirous of an amicable process."
My Lord, I am. It's not in my habit to interject, but it's not in my habit to interject. This documentary evidence speaks for itself. The opening paragraph says, referred to a meeting, did not refer to.
As God
As
pleases.
God pleases.
So, witness, that is correct. That the claimant have told you that he was, after raising all the issues, the grievances, she said she was desirous of an amicable resolution. Is that correct?
Yes.
Did you set up any grievance procedure or process to address those her concerns?
I had a meeting with Mr. Akshay Grover, who at the time was our CEO. I asked him to explain to me what happened and what the content of the conversation was. He refuted all allegations and he said that the conversation was a general catch up to his mind and he didn't feel that he bullied her. I also spoke to Akshay Grover's PA, executive assistant, and asked her if she's ever observed any bully behavior on his part, to which she said to her mind that she's never observed it, taking into account, sir, that I only recently then assumed the role of the chief people officer. I was in a different role shortly before I assumed the CPO role. So my investigation, in fact, was a little bit broader than just Mr. Grover. I just checked in with some of the people working close to him to understand his work style. And there was no evidence in that investigation, or rather in those questions, that suggested that he had the habit of putting people under undue pressure or bully them.
Thank you. My question really is, she raised several issues and asked that they be resolved. I'm asking whether there's a formal grievance process to address those issues. Was there a formal grievance process to address those issues?
There is if you're asking me, does a policy exist within the company? Yes, there is a policy. She raised the claim, I investigated the case.
Yeah, I know that the policy contains grievance process. What I'm asking is that when she complained, did you set up a formal grievance process? It's either you did or you not, yes or no?
It's neither yes or no, sir. I followed the process. Sorry?
Can you refer the court to any document before the court showing the outcome of that grievance process if you set it up? As court places. Yes, ma'am. As court places. As court places. As court places. As court places. We are grateful to your lordship for the guidance. So, Mrs. Susan, the question I asked is whether there was a formal grievance procedure according to your policy following this Exhibit 8 written by the claimant to you.
We didn't. If you
Yes. You understand that, please?
I think I understand, sir. So let me try and respond. Ms. Deribe raised her concerns, and I said that I would look into it, which I did, duly did. I went to Mr. Grover, our CEO. I spoke to him. I also spoke to those people around him to establish his common behavior. And it turned out that I could find no substance in that matter. I did at that very same point also said to Mr. Grover, as well as the the CFO, Mr. O'Toole, that we make sure that our processes are objective and disciplinary process asked for an independent chair to hear the case. It was based off the back of that allegation that we decided that.
Sorry, can you repeat? There seemed to be some bit of network issue while you were explaining.
Sure,
Slowly
sir.
this time, perhaps.
Huh? She's making reference to several people she met. She's making reference to several people she met. Ask her places. He's even going outside the question I'm asking her. Okay, so let me conclude this question by asking you, do you have a report, an outcome of that grievance procedure, if you had any?
Not a written outcome, sir. It was verbal feedback.
Thank you. What you did instead was to set up a disciplinary committee for the claimant by your email of 6th of November 2023. That was your response. You set up a disciplinary committee by your email of 6th November 2023, alleging several misconduct against the claimant. Is that correct?
Sir, not entirely.
2023, which is Exhibit 13.
I did set up a disciplinary hearing, but the disciplinary hearing and talking about the discomfort around Ms. Derube's conduct and some of the failure points within the risk system was already well aware by both her, the CEO, and the CFO. We didn't set that up in response to her allegation of bullying. That was already there. The disciplinary hearing was already looming.
Yes. I don't know whether my Lord got that. Exactly, my Lord. We refer the witness to that her email setting up the district committee, which of 6th of December 2023. Exhibit 13, my Lord. Witness, I put it to you yes, my Lord. I put it to you that you are not a witness of truth. Your email in question was actually in response, was a vindictive response to the claimant for raising those issues. Is that correct?
That's not correct.
Witness, please. The court wants.
What's your response?
I said it's not correct.
It's not correct that your email on 6th of December 2023 was in response to the claimant's complaint?
No, sir. I think there's two matters. The one was the disciplinary hearing was already being discussed with Mr. Ribe, and then she made the allegation that we are discriminating against her, which I said I would look into, which I then did, and I gave a verbal feedback. I also made the recommendation that an independent chair would be presiding over the matter. So my response was not based on her victimization and bullying claim. The disciplinary hearing already preceded that claim. We were already saying to her that action will be taken.
I want to read the first paragraph of
email.
6th of December.
I'll read the first paragraph and ask you again. No, let the witness read it. She should have it.
Can you read the
first paragraph, please?
Your email of
6th December 2023.
I'm sorry, sir. I do not have that in front of me.
You ought to. 6th December. Okay, I'll read for you. With my lordship.
Hold on, before you read. Hold on. Penal counsel, you didn't share the documents with the witness. You shared it because maybe they have another penal officer.
And we didn't share with her, but I don't think reading it out by him will pose any issue. I'm here to confirm, which is what I was literally trying to do.
So, yes, in the first paragraph, following my notes of the 13th of November, I want to let you know that we have today released an invitation to a disciplinary hearing scheduled for the 8th of December 2023 at 11 o'clock. Did you hear that?
Yes, sir.
Your note of 13th of November was your response to the claimant's grievance, where you had assured her that her grievances will be treated.
Sir, I see the matters as two different matters but related. Ms. Deribe wrote this note of complaint in response to a conversation she had with Mr. Grover, to which we were not privy. The organization distanced itself from that conversation, sir.
So, my lord,
the question I asked her is that
exhibit
11
or
exhibit 1. This morning. That's exhibit D1. Yes, D1. That's what I asked you. I wanted to read. I need to understand your question to know what to write.
So
Exhibit 1,
which was a
the response
to
to
the
the claimant's grievances. Can you actually repeat the question
Yes.
for the response to? Sorry.
Again, I say, it's not in my nature to interject. Exhibit B1 speaks for itself. My Lord, it does not only address the issue of
Counsel, you
discrimination.
already, please, that is not right.
No, my Lord,
When you are cross-examining, you are not disturbed. Allow the counsel to do
my Lord,
his
he disturbed me
cross-examination.
severally when I was cross-examining.
I didn't.
What you're doing is unfair.
As the court pleases.
He's entitled to do his case the way he knows best.
As the court pleases. My Lord, I will take some of this on address stage.
So the question is
that
was a
follow-up to
your email of
of November 2023. You said so in that email.
Sir, I see Mr. Ribe's grievance is different to the disciplinary hearing. Disciplinary hearing was discussed with Mr. Ribe already ahead of her sending that email to us complaining about Mr. Grover's behavior. So she was aware that we had already been experiencing issues and that the organization indicated to her already that some form of action will be taken as a result of the dissatisfaction. She then proceeded to send me the request that or the email that she is being bullied. To which I said we will distance ourselves from what happened to her and between her and Mr. Grover, and that we will ensure integrity of the disciplinary process, to which we appointed an external party to adjudicate.
Thank you. And please,
try to find your answer to the question asked.
Your question was, did I send her the disciplinary?
Now the witness to speak when she wants to, so that I can get the best from her.
I'm sorry, sir. Can you just repeat your question?
No, because
can you ask a question now?
So I'm asking
the question now. Prior to exhibit 13. What is exhibit 13?
That is the letter of 6 December 2023. Inviting
the claimant to the extraordinary committee.
The email
inviting the claimant to the extraordinary hearing
of 6
December 2023.
Before that, did you issue any query to the claimant?
I'm sorry, it's not clear to me what you are asking. There's an echo on the line.
So what
okay, hold on, let me mute.
So what I'm asking is that before your email of 6 December 2023, where you invited the claimant to a disciplinary hearing, did you issue any query to the claimant before that time?
There were ongoing discussions between
No, please, save the time of the court. You're a witness, you're under oath. Did you issue a query or not?
Are you asking if we had any other disciplinary proceedings?
I'm asking whether a query was issued before a disciplinary panel was set up. Please answer. Time is up.
I'm not sure what you are asking me.
Okay, hold on. Witness, the question is, you invited the claimant to a disciplinary hearing. Prior to that time, did you give a query? Did you ask the claimant to explain her conduct in writing? So that's the question counsel wants you to answer.
Thank you, sir. I personally was not involved in any of the preceding or the activities leading up to the formal hearing. Those were managed by Mr. Grover, and there were also questions asked by our People Board Risk Committee. but that was more a conversation on email between Mr. Rube, the people board, the people risk, or rather the risk committee, the Cellulant risk committee, as well as Mr. Grover and the CFO, Mr. O'Toole. I can't hear you. You're on mute now.
You're a human resources person. You know what a query is. The question is, did you issue a query before you send the letter of December 6th of December 2023?
No.
Thank you. May we have exhibit 1? So, exhibit 1 is the contract of employment, letter of appointment dated 3 November 2021. You have it. November 3, 2021. In that exhibit 1, by clause 19.12.
Witness, do you have the claimant's contract of employment?
I don't have it in front of me, sir, no.
You don't have it on your system either?
I have it on my system. If you allow me
You can
to
call
look.
it up. Yes, you can. Yeah, please do. We'll give you some time. Look for it. Have you found it?
One moment, sir. It's just slow.
Okay. Okay.
It is opening, sir.
Okay,
Right.
so counsel, you can direct the witness directly. So,
I have got it. You're on mute, sir.
So I'm saying by clause 19.12, if the claimant was terminated without cause, she will be entitled to $160,000 US dollars.
Sorry, you were mostly on mute.
Can you hear me now? Can you hear me? Witness, can you hear me? Hello, witness, can you hear me, please? Hello?
Sorry, can you hear the witness? Please.
I've lost you for quite some time.
Okay, can you speak now? Let's see if you can hear.
Okay, so I'm saying that by clause 19.12,
Yes.
if the claimant's employment were to be terminated without cause, she would be entitled to 160,000 US dollars. Is that correct?
A monthly salary was 20,000. So if it's 20 times 8, then yes.
So the answer is yes.
Yes, sir.
So the only reason why the claimant was not paid that 160,000 US dollars was because of the outcome of the disciplinary committee.
Are you asking me a question?
Yes, the question. Confirm whether that is correct. Is that
That's
correct?
her services were terminated in line with the disciplinary outcome.
No, what I'm asking you is this. If the disciplinary committee did not find the claimant liable, she would have been entitled to that $160,000. The only reason you didn't pay it was because of the decision of the disciplinary committee. Is that correct?
If the reasons for termination was different, then yes.
Please say it again because they don't hear you very well.
If the reasons for the termination of her employment with us were different, then it would have been that payment. But because of the dismissal or the termination, as we term it, it wasn't.
You are not answering the question directly. Let me put it another way. Yes. Yes. Okay. Okay. Ask her, please. Ask her, please. Yes, in paragraph 15 of your statement on oath, 15, statement on oath. You say that the reason for the termination was contained in the letter of termination. Can you look at the letter of termination and point out that reason to the court? Do you have it?
I'm just calling it up, sir. Give me. I've got it in front of me.
Yes. Can you point out the reason for the termination as contained in that letter to the court?
I'm writing to formally notify you that following the disciplinary hearing held on the 18th of December, your position as the company's Chief Risk and Compliance Officer is hereby terminated. In paragraph 15 of my statement, it says that we terminated as a result of the infractions identified on the part of the claimant for which disciplinary...
You have read the letter.
Sorry?
You have read the letter. I don't want you to interpret. Now, in paragraph 6 of your statement on oath, you said termination was pursuant to paragraph 19.1 of the statement on oath.
I'm not sure what you're asking me.
What is 19.1 of what?
19.1 of the contract of employment. Yes, my lord.
Paragraph 6 of your statement.
You have paragraph 6 of your statement on oath.
Paragraph 6 of my statement. Yes. Can you? What? Can you? I've read paragraph 6 and I've read paragraph
So my question is,
9.1.
in that place where you said the employment was terminated pursuant to 19.1, I now take you to paragraph 19.1. Right?
19.3.
Under that same 19.1 and 19.3, which you also refer to. No, sorry, my lord. It's not 19.5, my lord. I'm sorry. Witness, I'm referring to 19.5. 19.5. Clause 19.5. It was said in 19.5, you can see it.
I can see it, yes.
It is termination pursuant to clause 18.1 that would deprive the claimant of her entitlement. Is that correct? Can you see it? Is that correct?
I'm unsure what you want me to respond to. She was terminated for conduct reasons, and we calculated the dues in line with that.
Yes, my lord. My lord. I thought he stood up to say something.
There's an error, obvious error on the face of the document. In 18.1 is 19.1.
Yes, my lord. I refer to 18.1 and 19.5. 18.1. Yes, ma'am. Yes. So, madam, please, could you read out 19.5 to the court of the contract of employment, which you have before you? Please, with the permission of the court, read out paragraph 19.5.
In the event of termination pursuant to subclause 18.1, the company shall not be obliged to make any further payments to you beyond the amount of any remuneration actually accrued as at the date of such termination, and the company shall be entitled to deduct from such remuneration any sums owing to it. That is 19.5.
Yes. So it was pursuant to clause 19.5 that you withheld the 160,000, which would have been paid to the claimant as terminal benefits. Is that correct?
No, the employment was terminated, and we calculated the termination dues in accordance with the termination.
No, please understand me. You already agreed that the claimant ordinarily was entitled to $160,000. If not for her.
If she left on different
No,
for a different reason.
Let me explain before you answer. You already agreed that she would have been entitled to 160,000 US dollars, but for her, the manner of her termination, following the dictionary. Now,
No, she was terminated for misconduct.
No, I've not asked the question. Can you understand me and get the question? The question I'm now asking you is that it is clause 19.5 that we relied on to say that upon such manner of termination, you will not pay her terminal benefits.
So we didn't pay the terminal benefits because her departure was calculated for on dismissal.
It was not based on the provision of her contract.
So we followed the calculation to the letter.
I'll ask other questions. It's obvious that oh, I'm very sorry, my lord. I'm very sorry, my lord. So, witness, please. The question I ask you is whether the non-payment of the terminal benefit, the 160,000, was pursuant to the provision of clause 19.5 of our contract of employment, which we just read. Please answer. The court wants to record you. Witness.
Hold on. Counsel, hold on. Madam, are you here?
Sir, I can only say that the termination. I can hear you, my lord.
Okay, go ahead and answer the question, please.
Okay. The question was if we paid in relation to 19.5. My response is we paid in accordance with the requirements of a termination, which would be then the notice in lieu and the accrued leave, etc. So
that is not what the counsel. That is not the question the counsel asked. The counsel would like to know. Can you mute yourself, please? The counsel would like to know if, based on clause 19.5, you fail to pay the claimant $160,000, which was her entitlement. Do you understand that?
So let me just think about that.
Earlier in the proceedings, you had confirmed that the claimant would have been entitled to $160,000, but for the manner of termination of her employment. Then the question is, you did this based on clause 19.5 of the contract of employment. Is that correct?
That's correct, sir.
Thank you. So remember, so you have to be very clear when you're asking questions. I won't be doing this for you.
We very much appreciate your lordship. So, in the 19.5, clause 19.5 of that contract of employment, you said it will apply when the termination is pursuant to subclause 18.1. Is that correct? Please read it. Is that correct? You just read it a moment ago.
Yeah, I'm going to go and read through it now. 18.1. The parties acknowledge that you may create inventions. You said 18.1, correct?
0.5 first. 19.5. The first line of 19.5, please. First line of 19.5.
In the event of termination pursuant to subclause 18.1, the
Yes,
company
go.
shall not. Yeah. So then you want me to read 18.1 as well, sir?
Yes, so let's read 18.1 now. Thank you.
Is that clause referring to intellectual property rights?
In the contract of employment you have, read clause 18.1, please.
18.1, the parties acknowledge that you may create inventions in the course of your employment with the company and that you have a special obligation to further the interest of the company in relation to such inventions. You shall promptly, following the creation, disclose the
18.1. Yes. Sorry, my lord. My lord, let me ask my questions now. My lord, I don't like what is it. It's trying to put answers to the question of manifest error referring to. Are you the one testifying? Let the witness say it. My lord, what is it is not right. You keep suggesting answers to the witness. It's not right. So, witness, my question now is, was the termination of claimant's employment, was it pursuant to clause 18.1?
Sorry, I feel like I'm confused about the intellectual property rights and 19.5.
I'm as confused as you are, but you're in a better position to explain. The question is, the termination of the claimant, was it pursuant to clause 18.1? What is your answer, please?
No.
Thank you. Now, you agree that the defendant underwent structural reorganization. What is your answer, please?
Throughout 2023 and 2024, significant structural interventions were put in place at Cellulant.
I don't know whether my lord got that. I didn't get it. Witness, the question is, did the defendant underwent reorganization or structural changes during the time of this?
My answer is that Cellulant, as the defendant, underwent significant structural changes throughout 2023 and 2024.
Thank you. Pursuant to that restructuring, many management staff were let off. Is that correct?
I will answer that by saying many staff were left our business.
He said she said that it was many staff. I was asking whether management staff were let off. He said many staff. Please confirm to me, among the people that were left off were your chief growth officer? Yes. Is that correct?
She left our services, yes.
You are Chief Marketing Officer.
That's correct.
You are Chief Business Officer.
That's correct.
You are Chief Technology Officer, among others.
Not the Chief Technology Officer, no. So you may have to, you have to qualify, because I had several Chief Technology Officers in that year.
Just
So
wait. As my Lord done with recording. So I want to ask you, George Murage. Do you know George Murage?
yes, I do know him.
Was he among those that were left off? As well, please. Murage, my Lord. George Murage is spelled Murage.
Yes, sir. He did leave our businesses.
Yes, G like in Godwin. So I asked, was he among those that were? She said she know him. Yes, she answered that she know him.
I wasn't the Chief People Officer at the time.
Was he the Chief Technology Officer?
When I was in the business in a different role, yes, he was our Chief Technology Officer.
Yes, so do you know Andy O'Sullivan? Do you know O'Sullivan?
Yes, I do know him. But Mr. O'Sullivan joined after Mr. Ribe. So I don't understand the relevance.
The relevance is not for you, madam. It's for the court to decide that one eventually.
Thank you very much for helping me understand that.
So, I don't know whether my Lord got the last answer, so I can ask the next question. Yes. So, O'Sullivan is your Chief Technology Officer. Yes, Andy O'Sullivan. No, the present one.
No.
The other former, this is the present.
No, he's not.
Are you telling the lie?
I didn't say that. I didn't say that to you. My learned friend just said, I'm meeting to lie. He just mentioned a word, I'm meeting to lie. He said, PJ, I'm meeting to lie. He looked at you and said, I'm meeting to lie. That's not fair.
My Lord, I don't understand what.
You said that now, please. Take it back.
Take what back? Oh, please, he's just trying to distract me. My question to the witness is, Andy O'Sullivan is your Chief Technology Officer? And she said no. Yes, my Lord, just 3 more questions. 4. So what role? Remember, you're under oath. It doesn't matter whether you are in Nigeria or outside Nigeria. What role is Andy O'Sullivan occupying in your organization after Murray left?
Are you asking what role Andy assumed after George Murage left?
Yes.
He was a consultant in technology and he led the technology business. But he did not succeed George Murage. There were different role players throughout.
As the chief technology officer, was Murage in charge of technology?
At the start of 2024, I recall, yes.
Was he in charge of technology when he was chief technology officer? That is Murage.
Yes.
Yes. So you also testified that the claimant was entitled to stock options under her contract of employment. Is that correct?
She was given an allocation as part of her joining package.
That stock option that was vested on her was done pursuant to paragraph 11 of her contract of employment. It was a provision, paragraph 11.
Okay, let me read paragraph 11.
Please do.
So, okay, can you maybe just ask your question again?
So my question was that the stock that you testified that was vested on her in the course of employment, it was done pursuant to that clause 11 of her contract of employment.
An allocation of ESOP was made based on the contract paragraph I've just read. Yes, an allocation was made.
Finally, upon the termination of her employment up to date, you have denied her those stock options.
So her vested options, let me be clear on that, her vested options fell away because of her bad leaver status. Bad leaver status is determined by the way you depart, and it's also in agreement with the People Board Committee.
So what you are saying is that you took it away because of the manner of her termination.
I did not take it away. The scheme rules dictate that we assess the leaver status,
No,
and that
not really. The
status
defendant
is put
took
to
it away.
the People Board Committee.
But finally, witness the conversations that the claimant had with J, the CEO, that led to the dispute she had with the company. Yes. You were not physically present when those conversations took place.
No, sir.
My Lord, that will be all. And we are most grateful to your Lordship for your Lordship accommodation and guidance. Grateful to your Lordship.
Just two questions for the examination.
Thank you, Mrs. Fote, Mrs. Susan. Let me use that. So I have two questions. This is your examination now. So I have two questions for you. During the course of examination in chief, you were asked if a prior notice was given of the allegations against or a query were issued to Mrs. Deribe. Can you confirm if there was an attachment to that very email of 6th December by which you formally invited her to the disciplinary committee?
Disciplinary process dictate that you make available all documentation. So I would imagine that we would have given her all the documentation.
I'll leave it at this. She said that the disciplinary process policy prescribed that all documentation would have been given to her, and then she imagined they did that. These are documented. I will leave it at that. Imagination can overrule documents. Yes, my lord, the final question. You were can you please go to paragraph 6 of your witness statement on oath?
Yes, sir.
Yes. Can you please, you were asked questions regarding, or you refer to clause 19.1 that you terminated on the basis of 19.1 of the contract of employment. Do you confirm that?
Yes.
So you were then subsequently on that basis taken to 19.5 of the contract of employment. Do you recall that?
I was asked if 19.5 was taken into account. So I said, yes, well, we did take that in.
Yes, but now, when you, in that 19.5, the first line said pursuant to stop clause 18.1. And you also then refer to that same clause 18.1, which has to do with intellectual property, do you confirm that the sub-clause referred to in that 19.5 is actually 18.5? 19.1, sorry.
I suppose that is probably what happened, that it was 19.5, 19.1, and
19.1.
not 5 and 18.1, which
I... No, you can answer it. You can proceed with your answer to the court.
I said I assume that
okay, sorry. The sub-clause 18.1 mentioned, if she confirmed that clause 18.1 referred to 19.5 is actually 18.1, not 19.1. Not it speaks for itself. These are not matters we should do. It says sub-clause. My lord, I wouldn't know if my lord has not gotten the question and if the witness can answer. So, yes. What's your answer, please?
My answer is that I was asked to read 18.1, which referred to intellectual property, which I said I don't understand the relevance of 18.1.
And that's why I'm asking you to confirm. If you look at 19.1 and then confirm if the sub-clause referred to is actually 19.1, not 18.
That is correct. I believe that 19.5 and 19.1 and not 18.1.
And Lord, that will be all for the witness for your examination. My lord, that's all for the case of the defendant, my lord. Thank you, Madam Susan. I'll leave it to the court. My lord, we are grateful to the court for the indulgence.
Gentlemen, we'll give you January next year.
January next year.
So we can be sure that we'll take you, we need to adjourn your case if you're ready.
As the court pleases.
22nd, is it convenient? So, John, is it convenient for you?
My lord, yes, please.
Please, let's ensure, though it may appear distant, but by the end of the vacation, you discover that you have less than 3 months. So
Absolutely.
please, it does not detract from your 21 days and 7 days. You must send in your addresses, the soft copies, so that nothing hinders that day if we are alive and Jesus tarries.
As the court pleases.
So let's be sure that we do that.
As the court pleases.
Amen. January 2026 for adoption of final addresses. Please take the email addresses of the court so we can send the soft copies. Once you can give me the enclosures. Thank you. Thank you. Madam, thank you for your time.
Thank you, my lord.
So the case has been adjourned to 22nd of January 2026 for adoption of final addresses.
Thank you very much.
Thank you. Bye-bye.
Bye-bye.